Last sheriff called defense lawyers.
Douglas Minor, Douglas Minor, Douglas Minor. Mr. Askew, David Askew, David Askew. Taylor Askew, I apologize. Taylor Askew. And David Zetlin, David Zetlin, David Zetlin. They're not in the courtroom.
When the court broke the going chambers probably about an hour ago, I made an announcement that actually to the crowd that anybody could stay if they wanted to leave. I didn't instruct the lawyers to leave and go in. I advised that they have now left premises. And the sheriff confirmed to me that they're not in the courtroom and they're not in the parking lot. And they have told somebody that they would had to be in Knoxville, Tennessee, and they will leave. That's not the way it works. The court will, at some point, issue a show cause order to see why these defense lawyers should not be held in contempt of court and sanctioned by the court for their failure to be here for the ruling. They know better than to leave before the court makes the final decision. Now, I'm prepared to make my opinion and order in this case, and I'm going to read it to you. And it's going to take a minute, so you'll have to hang in here with me. Okay. In Trinidad's case, this matter is currently, first of all, can you hear me in the back right there?
Yes, sir.
All right. This matter is currently before the court on the petitioner's first amended petition for preliminary and permanent injunctive release and declaratory judgment. Petitioner in MEC number 4, and petitioner's motion for preliminary injunction, MEC 5, and the respondent's response in opposition to the petitioner's motion for preliminary injunction, MEC 12. The petitioner Trinidad Chambliss seeks an injunction with which preliminary enjoins the respondent's National Collegiate Athletic Association, NCAA, from prohibiting the petitioner from practicing, playing, or otherwise participating on the University of Mississippi intercollegiate football team during the 2026-27 academic year until such later time that his amended petition above is finally heard on its merits. After due consideration of the witnesses' testimony today, the exhibits and other proof presented, arguments from counsel, and applicable law, the court finds as follows. First of all, the court reserves the right to amend, modify, supplement, or alter its ruling based on any error in fact or law that I might make pursuant to the Mississippi rules of civil procedure. Petitioner Trinidad Chambliss, and I'm going to call him Trinidad, is an adult resident citizen of the state of Michigan, whose address is 3830 Burton Street, Southeast, Grand Rapids, Michigan, 49546. Since approximately May 1st, 2025, Trinidad is attending the University of Mississippi Ole Miss on an athletic scholarship and participated as an active member of the Ole Miss football team. The Respondent, NCAA, the National Collegiate Athletic Association, is an unincorporated private association of member colleges, universities, and athletic conferences throughout the United States. NCAA maintains its principal place of business at 700 West Washington Street, Indianapolis, Indiana, 46206-6222. Trinidad asserts only state law claims in this action. None of its claims are based on arise out of federal law. Likewise, the citizenship of unincorporated, give me that water back there, legal on this. It's gonna take a minute. Likewise, the citizenship of an unincorporated association like the NCAA is determined by the citizenship of all its member institutions, including without limitations, institutions such as the University of Michigan, Michigan State University, and Ferris State University, all of which are domiciled in Trinidad's home state of Michigan. See Staggs versus NCAA 2018 WL 409-2104. In parentheses, S period, D period, Cal period, August 28, 2018. In this court's view, there is no basis for removal of this action to federal district court based upon the federal question of diversity of citizenship. Jurisdiction and venue. This court has jurisdiction over all matters of equity, including petitions seeking injunctive relief like the one here. Mississippi Constitution, Article 6, Section 159, Mississippi Code annotated 9/119/1972, Mississippi High School Association Inc. versus Hattiesburg High School, 178 Southern 3rd, 1208, at page 1209, Mississippi 2015. Injunctive relief is within the jurisdiction of the Chancery Court. Pursuant to Mississippi Code 13-3-57, this court has in personam jurisdiction over the NCAA because it transacts its business in the state of Mississippi, including the organization of intercollegiate athletic competitions. Trinidad's cause of action arose from the NCAA's transaction of business in Mississippi. Venue is proper in Fayette County, Mississippi, under Section 11-5-1 Mississippi Code annotated, because the personal property interest which Trinidad seeks to secure, i.e., his eligibility to participate in intercollegiate athletics at the University of Mississippi, sometimes Ole Miss, is situated in Lafayette County, and also because Trinidad's cause of action arose in Lafayette County. Introduction. This action arises from Trinidad's claim that NCAA reached his contractual right as an intended third-party beneficiary to have the NCAA act in good faith and with fair dealing in interpreting their own bylaws and rules with regard to Trinidad's request for an eligibility waiver, so he can have the opportunity to compete in the upcoming 2026-27 college football season at Ole Miss. It is Trinidad's position that the NCAA, in its bylaws and rules, in an unreasonable and arbitrary way, which denies him this opportunity. On the other hand, NCAA has rejected the request for Ole Miss for an extension of the eligibility waiver on Trinidad's behalf because it did not fit within the narrow and defined circumstances provided by the NCAA's DI manual. This court is disinclined to agree with the NCAA's argument. While the NCAA acknowledges that there is a contractual relationship between the NCAA and Ole Miss as a member institution, and Trinidad Chambliss as an intended third-party beneficiary there too, they agree to that. But if this relationship is contractual, their mutual responsibility is owed by all parties, not just the member of institutions and the student athletes. The NCAA owed Trinidad the duty to evaluate and decide the eligibility extension waiver by the Ole Miss fairly, reasonably, and based on the totality of the circumstances here. For reasons stated below, the NCAA failed to do that. Trinidad enrolled at Ferris State in the fall of 2021. He was redshirted there in 2021, 21-22, and 22-23, according to Ms. Higley of the Fair State staff. There's some dispute related to his being a medical waiver in 22-23. Trinidad played quarterback at Fair State University in the fall of 2023 and fall of 2024. He transferred to Ole Miss in 2025 and played quarterback for Ole Miss in the fall of 2025 season. And accordingly, Trinidad has only played 3 seasons of collegiate football. The upcoming 2026-27 football season would be Trinidad's 4th and final season. And it is Trinidad's intention, the NCAA, in violation of its own bylaws and policies, is denying him the opportunity to compete as a student athlete in the fall of 26, his final and only 4th college football season. Trinidad first enrolled at Fair State in the fall of 2021, but medical and physical incapacity prevented his ability to adequately train and condition and develop athletics. Fair State redshirted Trinidad in the 21-22 academic year. Trinidad's medical issues did not improve and likewise prevented him from competing in collegiate football contests or games at Fair State in the fall of 2022. According to Tony Endes, the head coach of Fair State, and Sarah Higley, senior athletic director of Fair State, Trinidad Chambliss did not even dress out for any games during the 2022 football season. Keep in mind, the 2022 season is the season that we're concerned about, and will not be granted away. According to Sarah Higley, Trinidad was redshirted in both his freshman and his sophomore years, 2021 and 2022. That's not exactly correct, but that's what she said. And only competed in 2 seasons at 2023-24 and 24-25 before transferring to Ole Miss. Because Trinidad did not play in any games during the 22 season, Fair State did not file any paperwork with NCAA for a medical waiver. Affidavit of Taylor Hall, page 3 and 4, and letter of Sarah Higley of NCAA staff. It's NEC document number 5 and 4. Obviously, Trinidad's medical conditions were Trinidad incapable of competing in games during these years were beyond the control of him or Fair State. Trinidad's pertinent medical history. Trinidad was born August 24, 2002. He is 23 years of age. The cascade of medical issues which plagued Trinidad began in June of 2017 when he was 15 years of age. They continued through his high school and college careers and did not fully resolve until he had surgery intervention in December of 2024. There's substantial proof that has been provided to the court today, in which the proofs are provided by the NCAA by Ole Miss concerning Trinidad's medical history from 2017 through the end of 2024. Exposure to the Epstein-Barr virus, 2 lengthy bouts of infectious mononucleosis, COVID-19 exposure, and consequent chest pain, heart palpitations, shortness of breath, and dizziness, chronic tonsillitis, adenoiditis, chronic sinus congestion, swelling, infection, upper respiratory distress, mouth breathing, shortness of breath, obstructive sleep apnea, which resulting symptoms that included fever, nausea, loss of appetite, muscle weakness, breathing difficulties, sleep deprivation, fatigue, hypertrophy, tonsils, and adenoids that adversely affected Trinidad's abilities to train and compete athletically and significantly factored in the decision by Fair State to redshirt him during his first year of school and not to play in his second year. All of his medical proof is contained in today's record, and the court is relying on evidence making this ruling. The medical evidence is too important for this court to ignore, but for the sake of brevity and the interest of judicial economy, all of that medical detail is not being repeated in this order. We got a long way to go. In 2017, Trinidad was exposed to the Epstein-Barr virus, ET virus, and contracted infectious mononucleosis. On May 4, 2020, Trinidad suffered a recurring bout of infectious mononucleosis that resulted in severe and debilitating symptoms including fever, nausea, loss of appetite, muscle weakness, breathing difficulties, fatigue, significant swelling of the tissues of the neck, throat, and nasal cavities. Tonsils located and infiltrate germs within the body of the nose. The diagram includes intermittent petition, page 6, paragraph 20. Incorporated in by reference fairly accurately depicts the anatomical position of the tonsils and heading bones. I think Dr. Pike sufficiently advised us where those were and what to take it had on anything. Notably, these glands are positioned in the body at a location which present the potential for blockage, obstruction of the throat, nasal cavities, the body respiratory airways. December 31st, 2020, Trinidad tested positive for COVID-19 virus. His complaints and symptoms were fatigue, nasal congestion, loss of taste and smell. March 8th, 2021, Trinidad presented at a local emergency room with complaints of chest pain, heart palpitations, shortness of breath, and dizziness. He wore a heart monitor for 7 days to isolate whether the symptoms were related to COVID-19 or some undiscovered cardiovascular issue. Trinidad was prescribed Montelukast, which is the same thing as Singapore. Summer of 2021, Trinidad suffered from persistent tonsillitis and adenoiditis even after he enrolled in Ferris State. He continued to experience recurrent instances of swelling, inflammation, and infection of his tonsils and adenoids. July the 26th, 2022, Trinidad was treated for upper respiratory infection and his regular physician, Dr. Cheryl Dyson, referred Trinidad to Dr. Anthony Howard, was the board certified otolaryngologist, same thing as an ENT, regarding the hypertrophy of his tonsils. I apologize on that word. August 21st, 22, Dr. Howard was Trinidad immediately before his return to Ferris State for the fall of 2022 football season, the season we're concerned with. Medical records reflect a history of recurrent tonsil infections following mononucleosis. In 2020, Trinidad's complaints of upper respiratory distress, sore throat, snoring, and shortness of breath. Dr. Howard wrote, tonsils show 3+ bilaterally and are exophytic, or substantially enlarged with fleshy protrusions emanating from his tonsil tissue. Dr. Howard diagnosed Trinidad with chronic tonsillitis and adenoiditis and adenostellar hypertrophy. At a grade 3+, Trinidad's orthopharyngeal airway obstruction was on the higher side of the 51 to 75% range. I think Mr. Byron brought that out to our attention in his article. Airway obstructions of this degree, which impair the ability to fully breathe deeply, consequential to individuals who seek to engage in intercollegiate level athletics. Dr. Howard notes that Trinidad's symptoms will likely cause continued nasal congestion, recurrent illnesses, snoring, and sleep apnea. The notes even mention the effect of these conditions will have on Trinidad's school. Dr. Howard even recommends surgical intervention, which would require 6 to 8 week recovery and cause Trinidad to miss that much football season. Trinidad opted for single arm coordination to be continued and surgically and medical management treatment. In other words, he declined surgery in August of 2022. On December 21st, 2022, we followed up with Dr. Howard. Tonsils remained enlarged, and that Trinidad continued to suffer with chronic tonsillitis and adenoiditis. The word chronic is important. No infection at that time, and Trinidad generally described the status of doing well without recent tonsil infections. But adenostellar hypertrophy conditions remain. Tonsils range from 2 to 3+, and airways remained compromised despite no infection. Note that there had been 3+, now than 2, that's 3+. Airways remained compromised despite no infection. The NCAA improperly isolated Dr. Howard's December 21st, 2022 statement regarding no infection as the basis for Trinidad's denial. However, the court regards the NCAA's reliance here as misplaced. At that time, Dr. Howard was clearly not documenting the medical file on eligibility waiver, but instead wanted to give his patient better. In 2023-24, Trinidad persistently took singular Claritin provided by his mother, Sharon, and Flores compatible symptoms, including recurrent infections. These measures only addressed the recurring symptoms and did not prevent episodes of adenocellular swelling and the related respiratory impairment. Trinidad complained about these episodes to Dr. Howard in November of 2024. On November 2024, Dr. Howard's medical records reflect the chief complaint of large locked tonsils, several episodes of pharyngitis over the past year, snoring, and difficulty breathing through the nose. Realizing he'd suffered enough, Trinidad opted for surgery at the end of 2024. On December 30th, 2024, Dr. Howard doctor notes memorialized the adenostelectomy procedure performed on Trinidad under general anesthesia. Trinidad's bilateral tonsils and adenoids were surgically removed. Trinidad's tonsils were graded 3+, bilateral and the adenoids 2+. Dr. Howard further noted that the tonsils were cryptic, with the tonsil stone. Cryptic tonsils have deep holes called crypts. That traps food, particles, mucus, and bacteria which can, in Trinidad's case, harden into stones embedded in the crypt. In 2022 and until Ole Miss, his October 2025 request from the NCAA for an eligibility waiver, Trinidad could not foresee any need to obtain a medical opinion in 2022 relating to medical and physical incapacity to participate in intercollegiate athletics. Dr. Howard, in his regular practice, treats and reports the medical conditions of his patients, but he's not in the business of routinely creating records which opine on issues such as incapacity to play college football. Nevertheless, at Trinidad's treating position, the court finds Dr. Howard's opinion regarding Trinidad's medical condition and resulting limitations to be highly relevant to Trinidad's physical health and medical condition during the fall of 2022 football season, regardless of the date or time at which the opinions are expressed. In connection with this request for eligibility waiver, Ole Miss obtained on October 14, 25 written opinion from Dr. Howard, which directly addresses Trinidad's incapacity to participate in the fall of 2022 football season. Sections of Dr. Howard's letter attached here to the amended petition are quoted below with emphasis added. The following letter written by me in my capacity of board-certified otolaryngologist who has personally treated Trinidad Chambliss in August of 2022. Through the 2022 football season and into the 2023 athletic year, he continued to experience recurrent throat infections, poor sleep quality, daytime fatigue, exercise-related airway discomfort. These symptoms persisted despite appropriate medical therapy, including singular and intranasal corticosteroids. Before the surgical intervention, Trinidad experienced frequent episodes of acute tonsillitis marked by sore throat, otophalangy, tonsillar hypertrophy, and infections regarding medical treatment. These episodes led to significant sleep disturbance, increased daytime energy, and reduced airway comfort with exertion. Recurrent infections and disrupted sleep are well-recognized factors that impair endurance, conditioning recovery, and respiratory performance. Given the chronicity and documented impact of the symptoms, it is medically reasonable to conclude that chronic tonsillitis and related complications limited the ability to participate consistently and high-intense collegiate athletics during the 2022 season. These health issues affected his availability and performance during conditioning, practice, and game preparation. The board puts emphasis on this. You might recall, Dr. Ford Hyde elaborated that this was true in what he said. His testimony is corroborative of what Dr. Howard has said in his letter. Dr. Howard further says Trinidad underwent a tonsillectomy in 2024 after his symptoms resolved completely. Since surgery, he has had a marked improvement to sleep, airway, comfort, and overall health. His chronic tonsillitis represents a medically valid basis for hardship consideration, as his condition rendered him incapacitated and unable to participate in the 2022 season. Board placing importance on that. Ole Miss provided Dr. Howard's letter to the NCAA on November 24, 2025, along with letters from Ferris State's head coach Tony and East and Ferris State's former assistant head of sports medicine, Brett Knight, both of which attested Trinidad's incapacity in 2022. Both letters are attached to the event petition of exhibits MPC 42 and 43, respectively. It appears to the court that the NCAA chose to ignore the statements that Trinidad's treating medical doctor and other witnesses from Ferris State who had personal knowledge of Trinidad's medical and physical condition contemporaneous with the fall of 2022 football season. By ignoring these letters and other supporting medical documentation, the court is of the opinion that the NCAA erroneously and unfairly determined that Trinidad is medically and physically capable of competing in intercollegiate football and collegiate football fall 2022, despite not dressing out for and playing in a single game that season. The evidence, including the contemporaneous medical records which Ole Miss provided to the NCAA, is comprehensive, and it's clear that Trinidad Chambliss was not a healthy young man from his senior year of high school through the fall of 2022. He was physically unfit to engage in any meaningful way in the rigors of college football, or even train and condition himself for game competition. He was burdened with recurrent infections of his tonsils and adenoids, but even so when free of infection. Trinidad's adenocellular hypertrophy was present and made it difficult for him to fully and sufficiently breathe during high-intensity exertion. Trinidad's sleep was disrupted. He was constantly in a state of daily physical fatigue. Trinidad's college football history. Trinidad signed a national letter of intent with Ferris State in February 2021. The school is located in Big Rapids, Michigan, about an hour drive from Trinidad's home in East Lansing. Before reporting to Ferris State that summer, Trinidad attempted to train and condition himself for football season, but found it was difficult to do. At Ferris State, Trinidad participated mostly in drill work, football work, throwing sessions, and team practices. His practices did not involve a lot of sprint, distance running, to build stamina and endurance. Trinidad rotated with others on the scout team quarterback that season. He did not play in any games that fall and was redshirted from the 2021 academic year. Trinidad's therefore mentioned medical conditions returned in the summer of 2022, and they seriously compromised his training and conditioning workouts for the upcoming season. He was referred to Dr. Howard that summer and rejected Dr. Howard's offer of surgery in early August of 2022. Trinidad reasoned that the suggested surgery was too close to start the fall season. He wanted to play football. Trinidad opted to continue his conservative treatment for fear that 6 to 8 weeks required for recovery from surgery would jeopardize his ability to remain on the team and further develop as a quarterback. Trinidad's level of participation in the fall of 2022 was similar to that of the season before. He was an occasional scout team quarterback during practice, and school officials confirmed that Trinidad did not dress out for any game or play in any games during 2022 football season. We have a picture of him in the records that he was not playing, not in the uniform in 2022. Sarah Henry, senior associate athletic director at Paris confirmed to the NCAA that Trinidad was also redshirted during the 2022-23 season. That's debatable whether she actually said that he was redshirt. I think she was trying to say he was eligible for a medical redshirt, medical waiver, which given the Division II team, but they never filed paperwork to get the medical waiver. But we didn't play in 2023, never took a snap. Trinidad first played in football in the football contest at Ferris State against outside competition in the fall of 2023. Trinidad was third on the depth chart and did not get significant playing time in 2023. He played in probably 5 games that season, and mostly in a mop-up role after the scoreboard was officially lopsided in Ferris State's favor. Trinidad was named the starting quarterback at Ferris State in the fall of 2024. He played consistently throughout that season. As reflected in Dr. Howard's 2024 records, Trinidad still suffered from recurrent tonsillitis and adenoiditis. That season, Trinidad took special measures such as vitamin C, Claritin, and Flonase to reduce the severity of his infections. He also avoided exposure to illnesses by staying home rather than going out with his teammates. Trinidad experienced instances of shortness of breath in practices and games in 2024, but he felt better conditioned than in the 2 prior seasons. Trinidad transferred to Ole Miss. By the way, the NCAA takes great pride in saying how well he played in 2024 when Ferris State won the national championship for Division II. He transferred to Ole Miss after that in summer 2025 because compliance personnel at Ferris State and Billy Glasgow, former general manager of football operations at Ole Miss, both told Trinidad that the fall of 2025 would constitute his 3rd season back to participation in college football competition, and that he would have an opportunity to play 4th season football in the fall of 2026. Trinidad trusted and relied on these representations to make his transfer to Ole Miss. There's no proof in the record that they actually told him that, but that's what he believed that they told him, and he relied. It doesn't affect the court's ruling in this case, but that's what his request was, that he could play 2 more years. Since recovering from his December 2024 surgery, Trinidad has felt fully healthy, sleeps great, no longer snores, and has no lingering respiratory problems. He began his career at Ole Miss quarterback in the 2nd game of the 2025 season, remained the starter for the rest of the regular season, and led Ole Miss to the semifinal round of college football playoffs. He received multiple postseason awards, including the Conley Trophy and SEC Newcomer of the Year. The NCAA bylaws and eligibility rules. The NCAA states in its purpose is to support and promote healthy and safe intercollegiate athletics as an integral part of the education program, and the student athlete as an integral part of the student body. Division I manual Constitution 300. To achieve this purpose, the NCAA has stated that it organizes and regulates the 3-division system to create an opportunity for fair competition, to provide broad opportunities for participation. You can see an overview of the NCAA and the site that they have. At all relevant times, Ole Miss has been the Division I football program, and Ferris State has been the Division II program. Both universities are members of an institution of NCAA. Each NCAA division annually publishes a manual containing its bylaws, which govern competition, eligibility, and enforcement. NCAA member institutions such as Ole Miss and Ferris State agree to be bound by the bylaws. The NCAA oversees their enforcement. As a student athlete at Ferris State Division II and 9 at Ole Miss Division I, Trinidad is involuntarily governed and controlled by the NCAA rules, bylaws, and policies, which he has no right to accept or reject. He has no right to directly participate in NCAA governance or committee proceedings, and under the NCAA framework and bylaws, Trinidad has no voice or right to directly petition NCAA for relief. Such request must be made by the member institution, such as Ole Miss, because he's a third party beneficiary, not the right to directly bring suit. The Division I rules place significant emphasis on contests, i.e. games between different members of two institutions and a losing team. A contest is any game, scrimmage, or joint practice session with another institution team. Bylaw 17.02.2. Another institution team is referred to as an outside competition or an outside team. Division I bylaw 17.02-13. Accountable contest for a student athlete is any contest in which he competes or represents a member institution. Division I bylaw 17.02-4. The intercollegiate petition is considered to have occurred when the student athlete A represents the institution against an outside competition, competes in uniform of the institution or apparel received from the institution, or competes and receives an institution for competition. Division I bylaws 12.02.3. Division II bylaw 13.02.12. In numerous sections of the bylaws, the NCAA emphasizes that competition means competing against another intercollegiate team. Their practices and teammates do not constitute a season of competition. Even then, the Division I student athlete in football does not use or exhaust the season of competition unless he competes in 4 contests in a season. Division I bylaw 12.6.3.1.6. That's competes in 4 seasons, 4 contests. If a student athlete is a Division II football player, he does not use or exhaust a season of competition unless he competes in up to 30% of the maximum permissible number of contests. Division II bylaw 14.4.3.4.1.7. Further, Division II rules, which apply to Trinidad in years 21-22 and 22-23, Trinidad can participate in scrimmages such as the Scout Team, and in the spring, football without using such participation as a season of competition. Division II bylaws 14.4.3.4.1.2 and 1.3. In Division II, a contest is not even accountable for a student athlete unless he competes in the contest while representing a member institution. Division II bylaw 17.02.4. To reiterate, even though he participated in team practices, Trinidad did not compete in any contest against outside competition in the fall of 22 football in Prairie State. He also believed he was granted a medical waiver for the 22-23 season. Therefore, he did not use or exhaust any his eligibility in 2022 season in the intercollegiate competition in the 2026-27 academic year will represent only his full season in intercollegiate football participation. Division I and Division II waiver criteria and policies. I know this is important to you, but it's important to establish the decision I'm making today and what these regulations actually say. Only a student athlete who meets the governing athletic eligibility legislation and interpretations is eligible for intercollegiate athletic participation in a particular sport. Division I bylaw 12.02.1. The 5 to play 4 rule applies to Division I member schools such as Ole Miss. In other words, you got 5 years to play, 4 times 4 years of play. Under that rule, student athletes shall not engage in more than 4 seasons of intercollegiate competition in any one sport, provided that the student athlete's season of competition occur within 5 calendar years of the beginning of the semester reported which the student first registered for a minimum full program of studies at the collegiate institution. Division bylaw 12.6.1. However, the NCAA's athletic eligibility subcommittee may approve waivers of 5-year rule at the end of the program. Division I bylaw 12.6.1.7. Under this bylaw, a waiver of a 5-year period of eligibility is designed to provide a student athlete with the opportunity to participate in 4 seasons of intercollegiate competition. And the waiver may be granted based on objective evidence under certain circumstances, including the student athlete did not use the season of intercollegiate competition due to any institutional decision to redshirt the student athlete. 2, the student athlete was listed on the institution squad list and was eligible for competition during the segment of the season that concludes with the NCAA championship. And 3, the student athlete was deprived of an opportunity to participate in intercollegiate competition in one other season due to circumstances beyond the control of the student or the institution, which is applicable here. He did not have any control of his illnesses in 2022. It would appear that Trinidad Chambliss satisfied the requirements of this waiver criteria were fairly reasonably interpreted and applied in good faith. He was redshirted by Paris State in the fall of 21. Therefore, he did not use that season of intercollegiate competition. Because of the medical conditions, Trinidad was deprived of the opportunity to participate in the season in 2022 due to circumstances beyond his control or Paris's control. Circumstances considered to be beyond the control of the student or an institution included but are not limited to situations clearly supported by contemporaneous medical documentation that states that the student athlete is unable to participate in intercollegiate competition as a result of an incapacitating physical or mental circumstance. That word incapacitating has been debated here today. Division I bylaw 12.6.1.7.1.1 noted that this bylaw does not constitute an exhaustive list of circumstances which are beyond the control of the student athlete or the institution, and the NCAA's Division I manual does not define or enumerate what health condition may be considered incapacitating. Logically, the NCAA must rely on opinions of medical professionals, particularly student athletes treating physicians like Dr. Howard, to make such medical determinations. In assessing whether an injury or illness is incapacitating, the NCAA instructs its staff and personnel to use the same analysis as advised in hardship waivers. Under the criteria for hardship waivers, it is not necessary for the incapacitating injury or illness to be a direct result of the student athlete participation in organized practice or game competition. Division I bylaw 12.6.4.2.1. Importantly, contemporaneous or other appropriate medical documentation from a physical physician, medical doctor who administers care at the time of the injury or illness that establishes the student athlete's inability to compete as a result of that injury or illness shall be submitted with any hardship waiver request. Division I bylaw 12.6.4.2.2. That's exactly what Dr. Howard did. He presented the letter that would have qualified for a waiver. Clearly, the NCAA is not limited to considering only contemporaneous medical documentation. On November 19, 2014, its governing committee on student athletic reinstatement adjusted the reconsideration standard to permit new information supported by contemporaneous documentation to be submitted at any time, providing such information is germane to the original decision and not readily available. Report of the NCAA Division I COMM period on student athletic reinstatement, November 19, 2024. Therefore, NCAA staff is authorized to use contemporaneous and non-contemporaneous medical documentation and other supporting documentation demonstrating the student athlete was incapacitated. That's exactly what Trinidad did in the old days. They presented medical and information from the coach, athletic department, and other personnel that he was incapacitated and unable to play during the year 2022. Further, for transferring student athletes such as Trinidad, the application for hardship legislation for transfer of student athlete may be based on a method that will be most beneficial to the student athlete. The rule, highlight that it should be most beneficial to the student athlete. The rule applicable to the division in which injury or illness occurs or Division I rule. Again, Division One bylaw 12.6.4.2.8. In that regard, Division Two policy procedures updated this April 2025 provides this. If a waiver request involves medical documentation that does not clearly demonstrate that the requirements of the given waiver are met, non-contemporaneous does not state that leave is debilitating. The information may be shared with a medical expert. The expert will review the documentation and provide an analysis which will be included as part of the waiver request and considered by the legislative waiver staff and the legislative relief committee when reviewing the request. NCAA Division Two Legislative Relief Committee Policies and Procedures, April 2025. For reference here, the court takes note that the NCAA did not provide any expert never had to analyze or determine what the medical record said, what Dr. Howard said, to determine if they believed what he said was true. They simply didn't do anything. They just disregarded and denied Dr. Howard's analysis. Ole Miss provided this to the NCAA with more than Dr. Howard's medical expert analysis regarding this in Passion 22. They provided the NCAA with 90 pages of Trinidad medical records from Dr. Anthony Howard, Dr. Cheryl Dyson, that was his treating physician, and others who provided medical care to Trinidad. These medical records were not only contemporaneous to the fall 2022 season, but spanned the period from September 2012 to Dr. Howard's surgery in December 2024. In violation of his own policies, the NCAA ignored those medical records and the analysis and opinions of a board-certified otolaryngologist doctor who personally treated Trinidad in 2022. Ford died, a local ENT doctor, board-certified, same type otolaryngologist who practiced in Oxford and elsewhere in Long Mississippi, reviewed Trinidad's medical records. Dr. Howard's opinion led to the NCAA, interviewed Trinidad and his mother, and testified as an expert without objection by the NCAA. Dr. Dye concurred with and corroborated Dr. Howard's opinion provided to the NCAA. Again, the NCAA provided no objection or opinion contrary to Dr. Dye or Dr. Howard. Ole Miss request for eligible waiver. Ole Miss submitted its request for eligibility waiver to the NCAA in approximately October 2025, updated its supporting documentation for the request by transmittal of the same NCAA on November 24, 2025. The original request included the previous mentioned contemporary medical records. November update included Dr. Howard's letter and pertinent information. In December 2025, a phone call with Taylor Hall, Ole Miss Senior Associate Athletic Director of Compliance, an NCAA staff member admitted that Dr. Howard's letter sufficiently demonstrated Trinidad's incapacity during the 2022-23 season. However, the NCAA staff member still denied the waiver request due to an alleged lack of contemporary medical documentation. Ole Miss timely appealed this initial denial to the appropriate NCAA committee, which again denied the request for review. The NCAA issued public statements concerning the denial of the NCAA website and on X.com, formerly Twitter. The NCAA posted this public statement while on a phone call with Ole Miss compliance personnel. Ole Miss was not afforded any opportunity to share or communicate the outcome of Trinidad or his family or Ole Miss coaching staff. Trinidad learned that an outcome was seeing the decision posted on social media. The petitioner has shown that press releases about the NCAA are false or misleading in multiple respects. The NCAA stated in their press release, approval requires schools to submit medical documentation provided by a treating physician at the time of students' incapacitating injury or illness, which was not provided. This statement is totally false. The documentation provided by Ole Miss and the students prior to school include A physician's note for December 2022 visit was stated the student was doing very well since he was last seen in August of 2022. This statement cherry picks Trinidad's voluminous medical records and the misleading news information about the Howard's December 2022 findings of tonsillar hypertrophy and chronic tonsillitis and echoitis. The student's athletic prior to school cited developmental needs of our team's competitive circumstances as the reason the student athlete did not play in the 2022-23 season. This statement is false and misleading due to the failure to accurately state the information was fair state information provided NCAA. Sarah Hingley, Fair State's Senior Associate Athletic Director, Fair State supported an extension of Trinidad's other government stated in part the decision to redshirt Trinidad in the fall of 2022 was based on the developmental needs and our team's competitive circumstances at the time. He went on to say Trinidad also had a few medical problems that arose in the fall of 2022 season that could have played a role in the decision to redshirt him. Dr. Higgins letter concluded, though no fault of his own, Trinidad now faces the loss of competition that would have been entitled to be completed if he stayed at Fair State. The NCAA released its statement to the media on January the 9th, 2026. The morning after Trinidad and Ole Miss is competing against the University of Miami and its quarterback, Carson Beck, in the college football playoff semifinal game at the Fiesta Bowl. At the time of that contest, Carson Beck had been playing college football for over 6 years. Had attended a class for 2 years, I believe he said on television. February the 4th, 2026, subsequent of the filing of the amended petition and motion for limited injunction, Trinidad and Ole Miss received an unfavorable final ruling from the final NCAA body denying the request for eligibility waiver for Trinidad. That was just a few days ago. Breach of implied duty, good faith, and fair deal. We get that. Hang on. Members of Division I and Division II of the NCAA respectively, Ole Miss and Fair State have agreed to comply with NCAA bylaws and abide by and participate in NCAA's enforcement of these bylaws. In exchange for Ole Miss and Fair State's obligation, the NCAA promises to allow Ole Miss and Fair State to participate in intercollegiate athletic competition and to administer eligibility determinations in accordance with its bylaws. That is, the NCAA bylaws are a contract between the NCAA and Ole Miss. The NCAA rules agreed to by the NCAA and its member institutions constitute a contract. The contract is issue, in this case, is the NCAA Constitution, the NCAA Division I and Division II bylaws. They're voluminous documents which are publicly available at their website. They're also included in the NCAA's response to the amended petition and incorporated in this order of opinion by reference. Trinidad Chambliss is intended third-party beneficiary of the contract between the NCAA and its member institutions. This status is made clear by the NCAA's Constitution, which expresses its commitment to the well-being and development of Trinidad and other student athletes. Pursuant to this contract, the NCAA pledges to evaluate the eligibility of student athletes based on the totality of the circumstances and to reach outcomes and consider the well-being of the involved student athlete and to maintain fairness. Trinidad Chambliss, a student athlete currently enrolled at Ole Miss and formerly enrolled in Fair State, is the third-party beneficiary of the contract between Ole Miss, the NCAA, Fair State, and NCAA. See Mississippi High School Activities Association versus RT, 163 Southern 3rd, 274, at page 280, Mississippi, 2015 case. See also Battle versus NCAA, 2024 WL 4685604, number 4. North Northern District of Western Virginia, May 28, 2024. The Constitution and bylaws of the NCAA are binding agreements between the NCAA and its members for the benefit of student athletes. I put emphasis added. Also see Oliver versus NCAA, 920 Northeast 2nd, 2003, case 211, 2012. It's an Ohio court case, 2009. Holding the student athlete as a third-party beneficiary to the NCAA bylaws. Bloom versus NCAA, 93T.3D 621 at 623-24. Colorado Appeals Court, 2004. To the extent Bloom's claim asserts violation of duty of good faith and fair dealing arising out of the contract relationship between the NCAA and its members, his position as a third-party beneficiary of contractual relationship affords him standing to pursue a claim in his term. His status was made clear by the NCAA's Constitution, that is expressing his commitment to the well-being and development of Trinidad and other student athletes. Pursuant to this contract, NCAA is pledged to evaluate the eligibility of student athletes based on the totality of the circumstances and to reach outcomes that consider the well-being of the involved student athlete and to maintain fairness. This court finds that Trinidad Chambliss is an intended third-party beneficiary of the second contract. The NCAA Division I student athlete reinstatement committee subscribes students' first philosophy, including ensuring the individual athletes as well as the general student athlete body is at the forefront of every decision. NCAA Division I committee student athlete reinstatement guidelines reviewed April 2025. In keeping with this philosophy, the committee and restatement staff conducted work by evaluating the totality of the circumstances surrounding each case and by reaching an outcome that considers the well-being of the involved student athlete while maintaining fairness. I keep emphasizing that to maintain the well-being of the student athlete and maintain fairness. The NCAA did not evaluate the totality of circumstances surrounding the request for Ole Miss for a waiver for Trinidad Chambliss. All contracts contain an implied covenant of good faith and fair dealing. American Bank of Insurance versus Well, 819 Southern 2nd, 1296, 1206, Mississippi, 2001. Good faith is the faithfulness of an agreed purpose between two parties, purpose which is consistent with justified expectations of the other party. CNAC versus Murray, 609 Southern 2nd, 1257, 1272, Mississippi, 1992. In Mississippi, the duty of good faith attaches to both performance and enforcement of the contract. Davis versus General Motors Acceptance Corporation, 406, Grand Southern, 2nd, 698, at page 701. So Northern District of Mississippi case in 2005. And the covenant may be breached even in the absence of a breach of express provision of the contract. Henry Evans, 2012, WL 237423, Southern District of Mississippi, June 27, 2012. This law I just cited is contrary to what Mr. Minus stated. The duty of good faith and fair dealing prohibits a party from doing an act, refusing to do an act that impairs the right of the other party from receiving the benefits of both agreement. Topham versus Vickers, 759 Southern 2nd, 1241, 1248, Mississippi, 2000. The covenant imposes the duty not to interfere with the other party's performance and even in certain circumstances to take some affirmative steps to cooperate in achieving these goals. See CNAC 609 Southern 2nd, 1272. Including also Farnsworth, contracts, section 7.17, 526 to 27, in parentheses, 1982. A breach of duty of good faith and fair dealing occurs where there's some violation by the contracting party of standards of decency, fairness, and reasonableness. Licensing Act 609, Southern Second. That's what I'm saying. Citing the restatement separate contracts, section 205, at page 11, 1979. Examples of bad faith as breached and implied covenant include evasion of the spirit of the bargain, lack of diligence, willful rendering of imperfect performance, abuse of power to specify terms, and interference with the failure to cooperate with the other party's performance. The statement contracts, second, section 205. In the present case, this court is of the opinion that NCAA fell short in its mission to foster the well-being and development of Trinidad Chambliss as a student athlete. The mechanisms waiver rules for granting Trinidad an additional year of eligibility to compete at 4 years of college football are available and solely within the NCAA's control. Despite the duty of good faith and fair dealing it owes to Trinidad, the NCAA considers the evidence in Trinidad's case in an isolated instead of a comprehensive manner in the totality of the circumstances. The NCAA interpreted its rules to impose requirements not contained therein. It also took unreasonable and irrational positions. In this court's opinion, it behalf its NCAA acted in a manner that was contrary to the home bylaws and rules. This court was of the further opinion that the NCAA ignored rules favorable to Trinidad, and those rules were incompatible with NCAA's procedure to redetermine outcome of denying Trinidad's own waiver eligibility waiver. The court is of the opinion that NCAA breached its duty of good faith and fair dealing over Trinidad and acted in bad faith by denying him an additional year of eligibility so that he could compete as an intercollegiate athlete for the year 2026-27. The NCAA's bad faith and omissions include, but not limited to, the following. Its strange definition of contemporaneous, erroneous determination of almost 91 pages of medical records submitted in support of the waiver are not contemporaneous. In most dictionaries, the word contemporaneous means happening or existing at the same period of time, not simultaneous. It would impose an unreasonable burden on a member of an institution to produce medical records on any particular date selected as the subjective whim of the NCAA. Ole Miss submitted Trinidad's medical records which precede and follow the fall of 2022 season. Included were those medical records from 2024 that demonstrated that Trinidad's medical conditions persisted during its 10-year fair state and ultimately required surgery. The medical records provided are indeed contemporaneous with the fall 2022 season. The NCAA denied Ole Miss's waiver request based on pure semantics, taking the irrational and false position that the medical records submitted were non-contemporaneous and therefore insufficient. Its failure and refusal to fairly and reasonably follow and apply the waiver criteria and its own policies directing its committees and staff to use both contemporaneous and non-contemporaneous medical documentation and other supporting documentation to demonstrate that the student athlete is incapacitated and to analyze the waiver request under the totality of the circumstances. C, its failure to understand and appreciate the seriousness of the defined effects of Trinidad's medical conditions in the fall of 2022, which manifested in recurring infections, frequent nasal blockage, permanent airway obstructions, recurring sleep apnea, fatigue, that presented a clear case of incapacity to participate in intercollegiate football at any competitive level. Alternatively, the NCAA owed Trinidad an obligation to fully investigate the documented medical condition and gain appreciation of the impact of passion of fatigue, which the NCAA failed to do. Off the record, hang with me. Its dismissal of Dr. Howard's letter and other letters from witnesses who have personal knowledge of Trinidad's medical conditions and incapacity to compete in athletic football in the fall of 22, including Dr. Ford Knight, who testified here today. Since the information contained within such letter satisfy all the elements of the waiver criteria, and the failure to accept Dr. Howard's diagnosis in 2022 that Trinidad's tonsils were 3 plus bilaterally and were exoplanky or significantly enlarged. And in August 2022, Dr. Howard diagnosed Trinidad with chronic tonsillitis, adenoiditis, and endothelial hypertrophy, all of which was ignored and overlooked. On December 21st, 2022, Trinidad still had swollen tonsils and endothelial hypertrophy. However, NCAA committee said he was fine. They disregarded the doctor's records to show he was chronic, still suffering hypertrophy. It's amazing to me. It's a failure to interpret the evidence submitted by Ole Miss in the light of most favorable to Trinidad as a student athlete, in direct contradiction of the student's first philosophy designed to place Trinidad's well-being at the forefront of its decisions. It's failure to consider the Division 1 and 2 accountability laws, all of which demonstrate that spring and fall practices and even inter-team scrimmages do not count against the student athlete, do not constitute the student athlete's use or exhaustion of the season of competition, and its failure to apply such accountability laws, bylaws to Trinidad. In conclusion, reached in the decision-making process, it is somehow unfair to other athletes to grant Trinidad an additional year of eligibility when the vast majority of student athletes participating in intercollegiate football receive the benefit of bargaining by competing for 4 years of season football. Deprive Trinidad of the financial and other benefits flow in contract to the member institutions of NCAA. Eight, it's failed to honor and uphold the central purpose of Division 1 bylaws 12.6.1.7. The waiver rule to provide student athletes with the opportunity to participate in 4 seasons of intercollegiate competition. Instead, NCAA dishonored the waiver rule by interpreting and applying it to Trinidad in a manner that was antagonistic to the Vaught. I failure to fairly and reasonably apply the evidence submitted by Ole Miss to the criteria set forth in the waiver rule. J, its refusal to grant an additional year of eligibility to Trinidad when the NCAA has no evidence, which is contrary to or disputes the evidence submitted by Ole Miss. Its failure and unreasonable refusal to conclude the notifications which plagued Trinidad in the fall of 2022 constitute circumstances beyond Trinidad and fair space and control. Its failure to apply the Division 2 waiver policy to Trinidad, which authorized the NCAA and the benefit of the NCAA disagreed with Dr. Howard's expert analysis to obtain analysis from another medical expert. M, its issuance of false and misleading public statements and misrepresentation related to Ole Miss request for eligibility waiver, all of which demonstrate NCAA bad faith in print. N, it's inconsistent and consequently unfair, unreasonable process and adjudication of request for eligibility waivers by Ole Miss and other member schools and the athletes around the country. The court is asked to grant a requested preliminary injunctive relief which be consistent with good faith application of the NCAA rule, with the organization's stated mission to support student athletes, and with fundamental principles of fairness and fair dealing. Without this court's intervention, Trinidad will be permanently and irreparably deprived of access to college football labor market, consolidation of the stellar college career in the 2026 football season. Ole Miss and Trinidad's teammates will lose an important valuable intercollegiate student athlete leader. Broader communities which fall under the support of Ole Miss athletics in Mississippi nationwide will lose an opportunity to celebrate this player that is essential to the whole success of Ole Miss athletics and to the vast economic benefits which flow therefrom. This will deprive Trinidad of the very benefits of NCAA contracts with Ole Miss and Ferris State were intended to secure for student athletes. This court is also of the opinion that such harm cannot be fully adequately remedied by the get to the end. Preliminary injunction. Trinidad has requested an entry of a preliminary injunction under Rule 65A of the Mississippi Rules of Civil Procedure, which enjoins the NCAA from prohibiting him from practicing, playing, or otherwise participating on Ole Miss Intercollegiate football team for the 2026-27 academic year and until this matter is heard on its merits. In order to obtain such relief, Trinidad must show, number one, there exists a substantial likelihood that Trinidad will prevail when the case is finally heard. Two, the injunction is necessary to prevent irreparable injury to Trinidad. Three, the threatened injury to Trinidad outweighs the harm the injunction might cause the NCAA. And four, entry of preliminary injunction is consistent with public interest. Should the preliminary injunction be granted, Mississippi Rules of Civil Procedure 65C requires Trinidad to post a bond that the court deems for proper payment of costs, damage, and or equal attorney fees payable to the NCAA upon the injunction. The opportunity to participate in collegiate and intercollegiate sports has unmeasurable value to the student athlete. According to the NCAA guidelines, such opportunity offers physical, mental, and social benefits. NCAA Division I comment on student athlete reinstatement guidelines revised May of 2025. The right to be eligible to participate in college athletics cannot be viewed as mere speculative entry. There is a proper right to the present economic day. Gulf Shore versus Gulf S. Thomas versus Moore. 369 Southern Second, 553, 556 Alabama, 1979. See also Hall versus University of Minnesota, 530 Fed 7104, 109 D, Minnesota, 1982. Holding that the student's interest in attending a university is a property right protected by due process. In its present era, college football is the labor market for which student athletes are routinely compensated for revenue share from the institution, name, image, and likeness called NIL. See NCAA versus Austin, 594, U.S. 69, 2021. The controversy in this case centers around the application of Ole Miss to have an NCAA grant extension eligibility waivers to Trinidad Chambliss allowing him to play 4 years of eligibility under NCAA bylaw 12.6, 1.7, 1.1, which provides the following. Circumstances beyond control. Circumstances considered to be the control of the student athlete or institution do not cause participation in competition to be used shall include but are not limited to the following. It's adopted 8/10/94 and goes through 6/6/25 through 7/1/25. Situations clearly supported by contemporaneous medical consultation, which states that the student athlete is unable to participate in intercollegiate competition as a result of an incapacitating physical or mental circumstances. B, student athlete is unable to participate in intercollegiate athletics as a result of a life-threatening or incapacitating injury or illness suffered by a member of the student athlete's immediate family, was clearly supported by contemporary medical documentation. Trinidad as a third-party beneficiary of the contract between NCAA and Ole Miss, and his cognizable claim sounds in contract with Mississippi law. He's a third-party beneficiary who is subject to breach of good faith, breach of duty, good faith, and fair dealing. See Mississippi High School Association versus RT, 163, 274, 280, Mississippi 2015. Recognizing student athletes third-party beneficiary status. And American Bankers Insurance Company versus Wells, 819, Southern Second, 1196, 1206, Mississippi 2001. And provide covenant of good faith and fair dealing is impaired in all contracts for the bank. This court finds the NCAA's actions, this case violated by the bylaws and caused Trinidad to suffer breach of compliance duties of good faith and fair dealing. In order to proceed with the 65A, Rule 65A preliminary injunction, The moving party must demonstrate the existence of substantial likelihood that the movement will prevail on the merits and injunction is necessary to prevent irreparable harm. If threatened injury to the movement outweighs the harm and injunction might be to the opposing party, and granting the preliminary injunction is consistent with public interest. See Little John versus McAdams, 67, 169, and 170, Mississippi, 2011. Motions for preliminary injunctions are within the trial court's discretion. See City of York, Memphis County, Kentucky, Hospital, 587, Southern, 244, 250, Mississippi, 1991. In Trinidad Chambliss prevail on the showing of 4 factors identified above. This court says yes. There's substantial evidence that Trinidad will prevail on the evidence, on the merits. First, Trinidad has a cognizable claim. Trinidad clearly meets the criteria for eligibility extension waiver for 1 year. This is true based on the undisputed medical records of Dr. Howard, Dr. Dye, contemporaneous letters of Coach Dees, and athletic director Gidley, which both state Trinidad had medical issues in 2022 that prevented him from participating in football that year. Trinidad disputes the analysis by the NCAA that he has not had a medical issue during the fall of 2022, despite his attempt to conservatively treat his symptoms with singular employments. He will be able to testify to the struggles with fatigue, breathing issues, and poor stamina in 2022 that were operated by Dr. Howard's lab. Under Mississippi law, Trinidad is only required to show that the NCAA acted unfairly and unreasonably in the premises. Such conduct breaches the duty of good faith and fair dealing. See CNAC versus Murray, 609, Silver Second, 1257, at page 1272, Mississippi, 1992. The NCAA's disregard of the 90-plus pages of medical and non-medical evidence from Ole Miss, the findings of the only board-certified doctor who was based on a reasonable degree of medical probability, and it was that Trinidad could not have participated in the 2022 season was not credible, is disrespectful and almost ludicrous. Dr. Howard's letter alone justified granting Trinidad's waiver. Furthermore, the NCAA's history of inconsistent waiver decisions undermines the fairness of the process here. The NCAA never really sought the truth in its investigation, and therefore, based on the totality of circumstances and evidence, Trinidad could be successful on the merit of the matter of trial. The issues of preliminary injunction is necessary to prevent irreparable harm. The risk of irreparable harm is the primary reason for the issue of injunction. Triple J Calvin versus Chambers, 551, Southern Second, 280, Alabama, 1989. A significant number of courts have held that the fleeting nature of college athletics justifies injunctive relief to allow the athletes and players the ability to continue participation in the sport. Bigelow versus Quinnipiac University, 696, Ed Suffolk, Southern Second, 277, United States District Court of Kentucky, 2009. As the British reports noted, college athletes and by comparison, college coaches develop skill, self-sacrifice, learn team cohesion, and a sense of accomplishment, increase their physical and mental well-being, and develop lifelong health attributes. Richard versus Quinnipiac, 291. Trinidad, most likely every college athlete, has undoubtedly devoted a significant portion of his life seeking to become a successful college athlete, spending numerous hours performing and perfecting his football skills and abilities. The interruption of his ability to continue doing this would be irreparable, prevent him from competing at the level he desires. Popular versus NCAA 750 Fed 3B 527, Middle District, Tennessee, 2024. This court had no trouble concluding with many other courts have that the denial of ability to play sports is irreparable harm. Braham versus NCAA 794 Fed Sub Third, 829 Nevada, 2025. Denial of opportunity to play college sports in irreparable harm. Robinson versus NCAA 2025 WL 2409-203. In these post-NIL times of collegiate athletics, sports around the country now recognize the inherent value afforded by European intercollegiate competition. In Patterson versus NCAA 2026 WL 11-541-7, number 9, India, Middle District, Tennessee, January the 15th, 2026, the court stated that defendants correctly raised suspected the nature of the asserted irreparable harm, but the court refused the speculation and entitled debris. Of course, plaintiffs cannot know with any certainty what opportunity another season of play will bring, but the opportunity itself, once lost, cannot be recovered. On this basis, the court finds the plaintiffs have made a showing of some irreparable harm. In this case, the opportunity itself, once lost, Trinidad cannot be recovered. About 4 more pages. NCAA, you can't say I hadn't tried. The NCAA also argues that a 5-year rule allows the maximum, not a minimum, 4 season competition. Its position dishonors the purpose of the waiver rule, bylaw 12.6.1.7.1, which is designed to provide a student athlete with at least 4 seasons in the collegiate competition. In fact, the NCAA said as much in its denial recently have provided over this on January 9, 2026. And I quote, the purpose of the extension legislation is to ensure 4 seasons of participation opportunity. Taylor Hall, affidavit, MEC number 16. Further, Mississippi Intercollegiate Athletics Compensation Rights Act, Mississippi Code Section 37-97-103-109, Supplement 2021. It's a new law that was passed by the legislature in 2021. Prohibits the NCAA from enforcing rules that prevent student athletes like Trinidad from earning compensation as a result of the use of the student athlete's name, image, and likeness. Even though the waiver request here is for medical reasons, its denial effectively curtails Trinidad's NIL rights by prematurely ending his college career. Not only would an extra year of college eligibility permit Trinidad to monetize his publicity rights given performance last season at Food Player. Jimmy Judge, assistant head coach of the Ole Miss offensive quarterbacks, coach at Ole Miss, testified that he coached Trinidad in the 25-26 season, and he would be his position coach in 2026 should Trinidad be held for the clerk. Judge has a history of losing NFL coaching experience, including a stint as head coach of the New York Giants. He testified that the tradition of your college quarterback experience would be invaluable to Trinidad's chances of becoming future NFL quarterback. Without the Trinidad would be as a one-season guy based on his play and confidence from last football season. An additional year of development in college to transform Trinidad into what judges call multiple years play. According to Ole Miss quarterbacks coach, there have been only 4 NFL quarterbacks over the last 10 years who were one-season quarterbacks in college have sustained success in the NFL. The NCAA and the arguments today have made a big deal out of the fact that, well, he's just go to the NFL and make money there. Trinidad needs additional year of eligibility to improve the chances of contestants' football success. As the court season, losing that year, the opportunity for additional development will greatly lessen Trinidad's chances of success. As the court season, NCAA is preventing Trinidad from playing this coming year will cause him irreparable harm. The door will also close on Trinidad being unable to capitalize on receiving funds that he could earn from the normal social media and other ventures. Therefore, in my opinion, Trinidad has met the criteria shall be irreparable harm in this court. Number three, the threatened injury of the movement Trinidad outweighs the harm is an injunction likely to the opposing party NCAA. Again, Mr. Minor makes a big argument that this is going to really tear up everything in the country regarding NCAA. If this order is in. This court opines that the burden of preliminary injunction against the NCAA here will not unreasonably outweigh the benefit of Trinidad Chambliss will receive from the injunctive relief. The NCAA will continue its business as usual, suffering no immediate harm. One noteworthy point about the NCAA's response is its complete omission of Trinidad's well-being from the injunction equation, sharp departure from its student-first philosophy, in addition to reaching an outcome that considers the well-being of the involved student-athlete. To reiterate, this is not an antitrust action that seeks declaration from this court that NCAA rules are illegal. They're not contested, and I'm not ruling that the rules are illegal. Since the NCAA arguments concerning the alleged disruption of over 180,000 student athletes falls on deaf ears. Further, post-NIL and post-Austin courts have found that this alleged harm to the NCAA rules and other student athletes not outweigh the intending irreparable harm to the student athlete who petitions for relief. The balance of equities and public interest also weigh in favor of granting the injunction. The scope of injunctive relief sought is narrow to preclude the NCAA from enforcing the violations of Pavia to allow him to play next season while this case plays out. I'm reading what took place in Pavia last year. The NCAA's argument that injunctive relief in this case would be a sweeping change that will upend the Division I eligibility rules that apply across the board for 180,000 Division I student athletes at the local stadium. See defendant's response, document on 30, page 35. In joining the NCAA from enforcing the intercollegiate compensation rule as a topic for the next season will result in substantial harm to others of the NCAA. The NCAA's argument that preliminary injunction relief would suspend long-standing eligibility rules that apply to 500,000 NCAA student athletes in multiple sports if misguided fails to address the essence of the harm issue. In joining the NCAA for the 5-year rule as the breakdown, the next season will not result in substantial harm to others in the NCAA. That's in the case of breaking this NCAA. However, absent a grant of injunctive relief, breakdown is likely to suffer substantial. Absent a granting of injunctive relief, breakdown is likely to suffer substantial immediate and irreparable harm because he will be prevented from playing in the upcoming 25-26 season. According to the court, the court balances the equities in favor of breaking. The court balances the equities between the parties placed likely to suffer substantial and immediate and irreparable harm should they be prevented from playing this season. The NCAA, by contrast, will suffer little harm insofar as they should they not succeed on the merits. They terminate the claims that are good. Accordingly, the court finds the balance of equity weighs heavily in favor of the plaintiff who was breaking. Even though NCAA is a private voluntary association, it is not beyond the reach of the laws and the principles of equity. Chancery courts in Mississippi are courts of equity, and long followed the maximum of equity recognized by the courts in this day is a court of equity will order that which ought to be done. U.S. Fidelity Guarantee Company of Baltimore, Maryland, Lumber Company, 119 Mississippi 802, 81 Southern, 492, 1919. As the law in 1919 is still the law today. The balance of equities in this action also tip in favor of Trinidad. Further, the grant of preliminary injunction in favor of Trinidad will not likely harm the hypothetical student athlete if the NCAA argument will be displaced by Trinidad's conclusion the Ole Miss football roster. See Martinson 2025 WL 267804911. NCAA does not articulate any harm that will suffer. It only asserts speculative harm to other potential BI students. contrast, NCAA Martinson was suffering immediate irreparable in absence of a police. Application of this hypothetical is even more effective here, because Ole Miss football program may not have 105 student athletes on its roster for the first game in fall of 2026. And other than Trinidad, Ole Miss has signed all of the quarterbacks that it intends to accept on the roster for 2026 academic year, for what Austin Thomas about today. So nobody was going to be displaced as NCAA artists by Trinidad being granted this seat. Grant of preliminary injunction is consistent with public interest. Finally, the courts have determined grant of preliminary injunction in the premises serves as a compelling public interest of promoting increased participation and competition in the competitive football services labor market. Martinson, 2025 WL 2678049 The market for unrestricted NIL compensation has exploded since U.S. versus Austin. NCAA versus Austin. And even more significantly, the fact that NCAA members can now directly pay student athletes for the services. The market now is effectively a labor market for competitive college football services. Drops in 2025 WL 2409203. Free and fair competition in labor markets is essential to the American economy such that an injunction would serve the public interest. Northern District of West Virginia, August 2025, and Brayham, 794, Fed Sub SUP, Session 3D at 837. Here, the public interest is served by both free and fair competition in the DI market for college football. Conclusion. For the above reasons, this court decrees in favor of Trinidad Chambliss and grants his request for preliminary injunction relief and preliminary enjoyments of NCAA from prohibiting Trinidad Chambliss from practicing, playing, or otherwise participating on the University of Mississippi collegiate football team during the 2026-27 academic year. Trinidad Chambliss has demonstrated based on the evidence presented that he is entitled to an additional year of eligibility to the University of Mississippi, and the NCAA has failed in its argument to uphold that right. Further, Trinidad Chambliss has proven that exists a substantial likelihood he will prevail on the merits of the final hearing to be set at a later date. The injunction is necessary to prevent irreparable harm in Trinidad. These are the factors that have to be proven. The threatened injury to Trinidad Chambliss outweighs the harm an injunction might cause NCAA. And four, entry of this preliminary injunction is consistent with public interest. Therefore, the petitioner shall within 10 days post a de minimis bond of the clerk of the court in the amount of $7,500. So ordered with the judge decree this the 12th day of February 2026. Robert Whitwell, Chancellor. That's the rule of the court.
Let's see. I thought you should. Excuse me. Yes.
I know. Yeah.
Thank you, Tom. Thank you so much. Oh, it's lovely. Thank you.
Hey, buddy. Really good. Sir.
I appreciate the friend, you know, to hear all
Oh, yeah,
that
yeah.
because he's been through, yeah. He is